You believe that your doctor was careless, causing you harm and injury, and now you want to bring a medical malpractice case against him. Now you come to us to evaluate your case, and I turn around and say, listen, we do believe that doctor number one was careless and violated the standard of care, but we also believe that doctor number two was also careless and needs to be in this lawsuit. You turn around and say, absolutely not. There is no way I'm suing doctor number two. Doctor number two saved my life. There is no way I'm suing him. You know what we say to that? Come join me on this quick walk here in St. Martin on a deserted island as I share with you and explain to you exactly what this is all about. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you believe that your doctor was careless and caused you harm and injury. And now, guess what? All right, so I want you to join me on this walk through the neighborhood. Today's neighborhood is a deserted island here in St. Martin. If you look in the distance, you will see the French side of St. Martin all the way in the distance called Coralita Beach. Now, my wife and I walked across that water, that span which is only about up to thigh level. And now we walk to that island behind me, which is called, my wife likes to call it Shell Island, because there are lots and lots of seashells and lots of rocks, and she collects seashells. And then, as if the waters parted, as if Moses parted the Red Sea, now this part opened up and we walked across here to another little deserted island where she's busy picking shells. So I have a few minutes to share this great information with you. Okay, so you believe that doctor number one caused you harm and injury. He was careless. And you come to us to determine whether or not you have a valid case. During the course of our investigation, now it reveals not only was doctor number one careless, but doctor number two, who you believe saved your life, was also careless. And now we tell you, listen, if we go ahead with this case, we have to sue not only doctor number one, but also doctor number two. And you say, absolutely not. There is no way I'm going to go ahead and agree to sue doctor number two. I love him. He did great by me. There is no possible way. So what happens in that instance? Can we still go forward and bring a lawsuit just against doctor number one? The technical answer is yes, we could. You see, our expert in this scenario has confirmed that doctor number one was careless and caused you harm and injury. He's also confirmed that doctor number two was also careless and caused you harm and injury. So if we only sue doctor number one, what happens? If we sue doctor number one, now we have a problem. We have a problem because now there is an empty chair, meaning that there's somebody missing who should be part of this lawsuit who now is not part of this lawsuit. So now you might be saying, okay, if we don't bring a lawsuit against him, can't doctor number one and his attorney bring a lawsuit against doctor number two? The technical answer is yes, they could, but they will never do that. You will never find, or rarely, if ever, find a doctor and his attorney who will turn around and sue another doctor to include him as part of a medical malpractice lawsuit. It's just not done. They don't want to point fingers at each other if they can help it. So now you've sued just doctor number one. What happens as we go through the lawsuit? What will happen is that doctor number one will point fingers at doctor number two, who is no longer part of this case. He's never been part of this case. He's going to say, why did you sue me? I did nothing wrong. If anybody did something wrong, it was doctor number two. You should have sued doctor number two. And now, if the case goes all the way to trial, that's exactly the argument that doctor number one is going to make. Don't blame me for what happened here. I did nothing wrong. And even if I did something wrong, whatever I did not cause or contribute to this patient's injuries. In fact, it was doctor number two who was careless, and it was doctor number two who caused this patient harm and injury. Don't blame me because you didn't bring in doctor number two. Is that a compelling argument? Yeah, that is a very compelling argument, especially if we believe that doctor number two should be in this case. So now they're using the empty chair defense, which basically says, hey, listen, we didn't do it. The guy who should be sitting right here in chair number two, he's the one who did it, but he's not here. Put the blame on him. He's the guy. He's the guy. So that's exactly what will happen, and it is possible for the jury to come back and determine that doctor number two was totally at fault. Or it's possible that the jury will say, listen, doctor number one, we find that you are partially at fault, but we also find that doctor number two is partially at fault. And now they will apportion liability, which means they will have to determine what percentage each doctor is responsible for causing you harm and injury. So why do I share this quick information with you? I share it with you because I have a few minutes to give you this great information while my wife is busy picking seashells. And I thought it would be really interesting to learn what actually happens in these types of cases. I realize you'll have questions or concerns about your own matter. Well, if your matter did happen in New York, but you have not yet started a lawsuit, but have questions that need to be answered, what I invite you to do is pick up the phone and call me. I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.